Good evening, everyone. My name is Jim Militello, and thank you for attending our webinar. We know that this is an after-hours webinar, and we appreciate you taking your time to attend. So we'll give a minute or two here to wait for a few people to get on. Hope everybody is doing good this evening. And again, we really appreciate everybody taking the time to come to this. I think it's going to be informative and beneficial. Also, I appreciate, and we all appreciate everybody taking the time out of their evening and family to attend this. We realize that seminars and webinars and things like that have become the thing for the last year or two. I tried to get a seminar hall in order to host this, and obviously with the COVID and everything going on, I was not very successful with it. Plus, this is just a nice way for people to be able to attend and learn and get some information without having to go out. Also being mindful of everybody's time, and since it is 6 o'clock, we want to keep this webinar to about 45 minutes and keep it moving along so that people can get to their evenings. Again, my name is Jim Militello. I am the managing partner here at Prime Law Group. For those of you who don't know, we are located on Route 47 in Woodstock, just north of the viaduct. And if you're bring it up, we're across the street from Golden Rolls. So I hope you're not hungry right now, because they are actually a really nice place to eat. So we're in Route 47, and we will be impacted by this IDOT expansion. There's no doubt about it. We're right in the middle of it as well. And so thinking about how it impacts us, and thinking about how it's impacting everybody in Woodstock, and thinking about how it's impacting everybody in the community, we thought it would be important and informative to have this webinar. So some of you who may be attending today may be property owners. Some of you just may be traveling Route 47 and looking for information about what's actually going on and how it's going to impact. Some of you may be just looking for information on eminent domain, or a combination of all that above. Again, I thought it would be helpful to understand what is going on with this Route 47 project, and not just from our standpoint, but from everybody's standpoint, to know your rights and maybe learn a little bit about eminent domain. So I reached out to a colleague of mine. His name's Bryan Lynch, and asked him if he would do a seminar, and he said sure. So Bryan is with us today, and he'll be coming on here shortly. Also with Bryan from his office is Olivia, and from our office is Jordan. So while there may be some questions that may be going on, Jordan or Olivia may be typing and trying to answer those questions along the way. You're going to have some questions at the end as well, or as you go through this process. There's the question and answer place. Please don't hesitate to write a question in there, because Bryan's going to see those questions. Bryan's going to try to answer those questions. If there's something specific to you, please reach out to Bryan individually, and not across the entire group, but just send an email to him, or send the chat to him directly. Bryan has been helping property owners just like us and others on eminent domain matters for over 20 years. Bryan's written various publications and presentations on eminent domain. So this is right in his wheelhouse. So I asked Bryan, and again, knowing we only have 45 minutes today, I'd love to get a longer seminar or webinar out of this, but due to time limitations, we're going to try to keep it short and try to get everybody's questions answered as best as possible. But what is eminent domain? That's going to be obviously one of the topics. What is the IDOT process, and really where we're at on the project, and what can people anticipate as time moves on, what that process to be? A third one, which is directly on point with me, is what do we do when an appraiser shows up? The other day I was out of the office, and I came back, and one of the staff members came to my office and said, "Hey, Jim, here's a card. Appraiser stopped by." They had a look on their face like they didn't know what to do. I said, "Hey, thanks, I appreciate it, but great question. What do you do when an appraiser stops by and you're there? What do you do?" Great question. And again, any other questions that you may have along the way, again, Bryan's going to try to answer them as best as possible. So on your screen, there's the question and answer. So go ahead and submit it there. So with that, Bryan, I'm going to turn it over to you and go from there.
Thanks so much, Jim. Appreciate everybody taking the time to come out tonight. As Jim was saying, I'm sure that everybody's got a lot of other things that would be more enjoyable and a better use of their time than sitting in a webinar, listen to a couple of attorneys talk about the practice of law. There's a President Ronald Reagan who said something along the lines of, what are the 9 most terrifying words that you can hear? And that is, I'm from the government and I'm here to help. And I do think that applies in certain regards to eminent domain. When you're dealing with eminent domain, that is the legal authority that's in the Constitution, that's in the Bill of Rights, and it comes from our Bill of Rights, the eminent domain authority. The government has the eminent domain authority. That means they can take your property. But what is different and what was revolutionary about the Bill of Rights in this country back in 1776 was that it came about and required an obligation for the government to pay the property owner when it took the property. Prior to, in England and the common law, the government could take property and not pay. And that was a big distinction. And that's why it's so important. That's ingrained in our Bill of Rights and our Constitution, and it flows into the Illinois Constitution as well in Section 15. So what is the government obligated to do? When they take your property, they're obligated to pay you. And when you're looking at it, you're trying to make a determination about what are they obligated to pay you for? And many people have certain concepts of, can I make them take my whole property? And most of the time, the answer to that question is no, they won't take more than what they need. And sometimes you may scratch your head and say they seem to be taking more than actually what they need to complete the project. But it's a pretty kind of set standard. They can take only what they need, but it doesn't have to be essential. So they can only take what they need, and they have to pay for it. And not only do they have to pay for what they're taking, they have to pay for the damage that it causes to your property. And that's the main issue in these partial taking cases, which is what everybody for the most part is experiencing on Route 47, Eastwood Drive, is that a partial taking. And it's not really so much a focus of the case and the valuation. Are they paying me the right price per square foot for the land that they're taking? That is an important point, and that is a point that we look at, and every experienced condemnation attorney should be looking at. But the main point is, are they properly taking into consideration the devaluation of your property because you're losing that strip of land? Are they factoring in the loss of functionality, the maneuverability, loss of marketability, because now your property is smaller, because it maybe doesn't comply with zoning, because you've lost parking, because you've lost signage, and the list goes on and on. There are many impacts to these partial taking cases that comes into play. So they have to pay you for what they've taken. They have to pay you for the reduced value of your property. And then they have to pay you. There's another thing that many of the properties along Route 47 will experience, which is a temporary easement. They have to pay for the temporary easement. What is a temporary easement? Temporary easement is the land that the government takes for a temporary period of time. In this project, my expectation is that the easements will be 5 years. Why do they take that land? Because they need to be able to stand somewhere, place their aggregate, place their forming tools, etc., on the property whilst they're working on the new right-of-way, the land that they've taken from you. And they can't do that. They have no legal authority to do that unless they have acquired those property rights. So they have to pay you for the temporary easement, and in turn, they have to pay you for any diminished value to your property as a result of the temporary easement. So let's say they're impressing a temporary easement. They're just going to impact your parking temporarily, but so it stretches across your parking stalls. They have to pay for, and you have a strip center, they have to pay for the devaluation of that strip center because it's lost parking. Maybe it hasn't lost all of its parking. Maybe it's only lost a quarter of its parking or a tenth of its parking. They have to pay for all of those parking stalls that they're impacting. And they don't pay on a per parking stall basis. They pay based upon what the appraiser's opinion of value is. And that's, an important point that I think that comes into how things are valued. And I'll touch on that a little bit when I get into the eminent domain process and laying things out about the appraisal process. But they have to value all of those things. And it should be comforting to know to all the property owners that are affected by this project, there's only 2 ways that IDOT can acquire your property. And the first way is if you sign a contract with them and a deed. If you sign that, then you know what you're doing and you know what you've done. You've signed that. And my suggestion, recommendation would be that you don't sign anything until at least you've talked to an experienced eminent domain practitioner. Many attorneys practice in real estate and other areas, but eminent domain is nuanced. It's not the most complicated area of law, but it's certainly an area that has certain technical requirements that if you run astray of those technical requirements, you can find yourself in a bad valuation situation. So you need to make sure that the valuation issues are being thoroughly looked at by somebody's experienced in eminent domain. So the first way, again, is if you sign a contract and a deed. The second way, which is the way that I recommend to property owners, hands down, and this is the process that I suggest and recommend to almost all of my clients, is that they go through the legal process. And that's when the judge enters an order setting the amount of compensation that the Department of Transportation must pay for the property it's taking. It's more involved. It's more of a time commitment on my part, but at the end of the day, the property owner will receive a substantially different and greater amount of compensation through that than if they were to try to negotiate, or I were even try to negotiate with IDOT outside of court. The court process provides greater protections through the Illinois Eminent Domain Act, and it allows the judge to get involved in the process to help determine what fair compensation is. And this isn't a process about just trying to think you maybe, and I'm sure that most property owners don't approach this. They're just looking for fairness and to be treated fairly. And that's all anybody can ask for. But it's not a process where you're going to find yourself in a financially rewarding situation. The best alternative is that this project were never to happen. So it's important to know that those two ways. So when you're dealing with IDOT, you should know that in essence, the property owner has the upper hand. The property owner does not have to convey its rights. It doesn't have to worry about what if I don't do this? What if I don't agree with them? What if I don't allow them into my property? What if I don't accept their offer? Can I negotiate? Yes, you can negotiate. No, you don't have to let them into your property. No, you don't have to accept their offer. And no, they cannot pay you less compensation because you elected to exercise your constitutional rights and require that they go through the court process. This isn't a process that necessarily means you have to initiate it. It's what IDOT has to initiate, and IDOT knows that, but they will approach you as if you don't agree, they're going to take you to court, and they frame it in a way that they try to frame it in a way that places the burden on you or creates trepidation or anxiety in you, and it should not at all, because that is a greater burden for them, and they know that by going through the court process that they'll be paying you greater compensation. What is eminent domain? Eminent domain is in essence the legal process. It's the legal process that's laid out. Condemnation is kind of the body of law, the legal rights, and eminent domain is kind of laying things out from the legal process standpoint. And how does that all work? As Jim was saying in his opening remarks, an appraiser came out to the property. That's the start of the process. Though IDOT has been working on this process for years with its attorneys and its engineers and its land planners. They've been working on it for years before this appraiser comes and knocks on your door or sends you a letter. And so when they're coming, they're fully aware of what the project is and what's going on. So they have to come out and appraise your property and appraise all those aspects that I previously touched on: the value of the part taken, the damages, the temporary easement, the damages that are arising from the temporary easement, and all of those comprised together are a number called the just compensation, or basically the award, the payment that you receive. And the appraisers that come out, I wouldn't look at it, and in the whole process, you deal with a number of different people. I think it's important you treat everybody with respect and treat everybody in a cordial way, but know that these appraisers that are coming out are hired by IDOT. They're paid for IDOT, and they do 90% of their work for IDOT, for the Illinois State Tollway. They are what we refer to in the condemnation arena as a condemner or appraiser. They do work for the government. They know why they get these contracts, and some of them make millions of dollars a year providing appraisal services. And they get that because they come to valuation conclusions, and it's an objective. It's not I should say it's a subjective. It's not an objective analysis. It's not 2 + 2 = 4. It's what their opinion is. And the opinion that's flowing, that they're going to reduce into the report that's flowing from them, is an opinion that I think is biased to a degree, and it's framed by their years of experience in doing appraisal work for the condemning bodies. They're very conservative in their valuation conclusions and saying that what the value of your property is. And they're very optimistic saying, oh, your property's not going to be harmed by this. There's not going to be a negative impact. I think that's a very incredible statement from when you're looking at the impacts that are being proposed by IDOT to these properties, to say that the market, the real estate market, and that's how it's supposed to be valued. It's not what the property owner thinks or what I think or what IDOT thinks. It's how the market will react. What will a willing seller and a willing buyer pay for the property? And so when you look at the property, you're looking at it in the throes of the construction, and with the part that they are taking in fee simple having been taken and placed under IDOT's ownership, and the rest of the land being under construction that they are going to use. And that's how it's supposed to be valued. And to say that the market is not going to react negatively to those things, I find to be incredible, because oftentimes they do take that approach. Not always, or they might say that there is an impact, but it's a very small impact, and they don't allocate proper compensation for that. So the appraiser will come out, he'll value all of these things, and then after they complete that, the appraisal report will go to what's called a negotiator, which is another party that's hired by IDOT, and that person comes out. Many times they are an attorney. They're not coming out as an attorney for IDOT. They'll come out and they'll contact you and ask you, oh, we want to give you the offer. And they'll give you the appraisal report, and they'll give you what they call a plat of highway. You may already have gotten a plat of highway. It looks like a survey. It's a larger document. It shows your property, but it's surveyed in essence from not from the perspective of what you own, but it's from the perspective of what IDOT owns, which is Route 47. And then it also calls out on there what they are seeking to take in fee simple and what they are seeking to take in as an easement. So they'll give you that. And they'll give you a handful of other documents, such as a deed and a title commitment. You'll get all of those documents. My recommendation to property owners is, and you're well within your rights, to simply ask them to email that paperwork to you. Email copies of all of that to you. Why do I suggest that? One, you've got it in a convenient format, then in the PDF to look at it. You can look at it and at your leisure. You're also able to zoom into those documents in greater detail, especially the plat, to see certain things that might be called out in there that aren't necessarily apparent when you're looking at it in a printed format. But when you can zoom in on it, it's very handy and can be very informative. So I suggest that you have the documentation emailed to you, because then it's, as I said, a readily more usable format. Another thing that's important to know about the negotiator that will contact you, and they can be very persistent, and I'm putting it politely, they'll be very persistent. If you give them your email address or they've got your cell phone number or anything, they will call once they give you the offer, and they will email you weekly, sometimes more than once a week, saying, hey, have you looked at the offer? Do you have a response? Are you willing to accept it? It's almost like they harass the property owners to the point that I think they try to wear some of the property owners down. Know that you're well within your rights to either ignore them, you have no obligation to talk to them, or to simply say, look, I'm not willing to sell my property to IDOT. I'm not interested in accepting the offer. There are a variety of ways you can approach it, but know that you are not under any obligation to negotiate with them. You are not under any obligation to meet with them. You are not under any obligation to present a counter offer to them. And all of those things, if you don't do them, they can't use those things as a basis to say you're not going to get fair compensation, or we're going to pay you less money, or they're going to alter the legal process. They're not entitled to do that in any respect. And so you should be confident in knowing that you're in a kind of a superior situation, though it might be uncharted territory for you and you might be uncomfortable with the process. It's one in which the property owner definitely has the upper hand because it is not compelled to do anything. The only way the government, as I said, can acquire your property is if you don't agree, is if they go to court and then the judge enters an order. And if that happens, you're involved in the process. and you're fully aware because they have to serve you, and there's certain legal protections that exist. So having laid all of that out, what happens then if you don't accept the offer of the government? It's something that they end up having to file a lawsuit in McHenry County up on Seminary Avenue in Woodstock. And there's two judges, Judge Thomas Meyer and Judge Kevin Costello. I routinely appear in front of both of them. They're fair-minded judges, and that's exactly what any property owner could hope to get and ask for, is a fair-minded judge to hear the issues. So IDOT has to file a complaint. Once they file that complaint, they have to give you a copy of it. And then what happens is they will file what they call a motion for immediate vesting of title, or a quick take motion. What is that? That's like a mini bench trial. It's a mini evidentiary hearing that is conducted by the judge, in which IDOT presents its engineer and its appraiser to tell the judge what they believe to be the fair amount of compensation that you're due. And at that point in time, the property owner is given an opportunity to cross-examine them, to ask them questions, and to present an opposing opinion of value, opposing opinion of compensation. And that's why this hearing is extremely important. I can't stress the importance of this hearing enough. And well in advance of this hearing, whether it be my firm or another firm, I would suggest that property owners retain counsel that's experienced and knowledgeable about eminent domain, because you have to prepare for this quick take hearing by getting an engineer, getting an appraiser, sometimes an engineer, and preparing for it. It's like anything in life. The more you're prepared, the better off you are, the better result that you get. You have to prepare for this hearing, and that's the attorney's job, is to make sure you're prepared. And we look at everything like the zoning setbacks, impact to drainage, impact to sign setbacks, parking setbacks, loss of parking, circulation. If they're closing a driveway, are they narrowing the new drive? Are they narrowing the opening so that you no longer can get in the same size vehicles? I have a client in this project who we've got a concern about that, and they're going to be narrowing and closing driveways. Are trucks going to be able to get in and out of the site in the same way in the after as they could in the before? And that's going to be a very important issue, but that's going to take time to prepare. That's not something that you can throw together in a couple of weeks and be prepared to have have the engineer conclude that, and then have the appraiser take those impacts into consideration from a valuation standpoint. All of that takes time, and you just want to be prepared. Again, anything you do, whether it's purchasing a house or buying a car or taking a job, you take time and you prepare for that. And I can't stress that enough for the condemnation. You need to prepare. And IDOT has been preparing for this project years in advance, and you now are seeing them coming out and doing things to formally engage the property owners to further this project. You'll have this hearing, and at the conclusion of this hearing, it's a bench hearing. It may take an afternoon. It could take an entire day. It could take 2 afternoons. It depends on the court schedule. But at the conclusion of that hearing, the judge will make a determination and say, IDOT, you have to pay X dollars. IDOT can't say, oh no, judge, we don't want to pay that a dollar amount. We think it's too much. IDOT has to pay the dollar amount that the judge states. And once IDOT has paid that money, which is probably about 45 days after the hearing, IDOT pays that dollar amount. And once they show the court proof that that money has been paid, that the judge has ordered, then the property rights to the fee simple taking or the temporary easement get vested in the Illinois Department of Transportation. Now, a question probably a lot of you have is, do I get the money? Where does the money go? Does it go to the court? No, the money doesn't go to the property owner, and the money doesn't go to the court. It goes to the McHenry County Treasurer, Glenda Miller's office, and they hold the money. And then we present papers to the court asking the judge to enter an order directing the treasurer to disperse out those dollars to the property owner. So there's a formal process that you have to engage in to do that. But the quick take is super beneficial for the property owners, and I can't stress enough that you need to prepare for that, because the takings in this project, some might be a little bit more straightforward, but most of the takings in this project, with the construction of the number of roundabouts and the road widening and the route that current Route 47 travels and it turns, there's going to be some significant impacts to the properties along Route 47. And so you just need to prepare for these things. After the judge determines the amount of money, and it's not a final number, it's not a number the case is done once the judge decides it. Many times the parties will agree that that number that the judge has decided is the final number. But that is, they're not required to agree. IDOT, that is not required to agree to the number determined by the judge, and nor is the property owner. If we feel that the judge hasn't given you fair compensation, we can continue to litigate the case to get more compensation. If IDOT feels that the judge awarded you, the property owner, too much money, IDOT can request that a partial refund be made to them because they feel the judge awarded too much money. Nobody is obligated to, the IDOT's not obligated to pay more money, and the property owner is not obligated to refund any money. The parties strive to reach an agreement, and if an agreement can't be reached, they engage in further litigation. But as in most cases, and Jim can confirm this, say 95% of all litigation cases probably settle. In condemnation, it's even greater than that. It's probably 99%. Why? Because it's not a question of do they have to pay, which is preliminarily the issue that comes up in most litigation. Are you obligated? Did you breach the contract? If there's a labor dispute, is the employer obligated to pay the employee? Personal injury, is the plaintiff entitled to compensation from the insurance company? So there's the first issue is, are you obligated to pay? And the second one is how much? In condemnation, the first issue has already been decided by the Fifth Amendment of the United States Constitution and Section 15 of the Illinois Constitution. Yes, they have to pay. The only issue in a condemnation case, and that makes it very unique, and there's only one singular issue, is what's the amount of compensation that the government must pay the property owner for the land rights that they are taking and the damages that they are causing to the property. That's the only issue. So it makes it very straightforward. And because it can be very straightforward in that regard, and because the issue where they're required to pay compensation has already been resolved century and a half ago, it's very clear, and it allows these cases to resolve themselves on their own. So I think that should also give property owners comfort to know that just because you engage in the legal process, no property owner should expect or anticipate or believe that you're going to be tied up in litigation. And the property owner has very little that it has to do, very little obligation or burden or participation in the legal process. The property owner makes all the decisions in the process, but it has little obligation to come up with opinions or to appear at court hearings, or I'd say it actually has none, because it really comes down to what does our appraiser say? And there's various appraisers and engineers, as I said, that we work with, and we are able to bring on board to help us in this process. And that's an essential part of the condemnation process. But the property owner has very little obligation in this process. So you shouldn't look at it as some additional task that you're taking on, or some sort of multi-year piece of litigation that's going to be hanging over your head. That's not the case at all. And so when you're looking at it, most of the cases will settle. If they don't settle, you'd have a right to a trial by a jury. But typically, and this, I think IDOT looks at it in the same way, the property owner and IDOT have to be hundreds of thousands of dollars apart in order for it to make sense for either side to elect to go the route of the jury trial, because the costs associated with that can be significant. Short of a jury trial, there really aren't that many costs. There's a cost for the appraiser, depending upon the issues in the case and the complexity, that can range, but it's something probably around $2,500. And you might say, wow, that's a bit more than I expected. It's a commercial appraisal report. There's very few appraisers who can do an eminent domain appraisal. The appraisal report isn't something that you see for like a lender, where it's very kind of streamlined and form oriented. These are a little bit more beefier documents, and there's three valuation conclusions. There's the value of the property in the before, there's the value of the part taken, and then there's the value of the property in the after. So there's multiple value assignments, value conclusions that are contained in those reports, as well as the fact that you're not just paying for the report, you're paying for the individual who wrote the report, the individual who's comfortable and confident in their conclusions to be able to explain complicated valuation principles to the judge and breaking them down simply to be able to withstand cross-examination by IDOT and not become kind of hesitant or start second guessing themselves in the witness stand. These are individuals that are tested by fire, going through quick take hearings, going through trials, that are very confident in their skill set and are very experienced in eminent domain. And as a result, the more experienced you are in a particular area, your fees are reflective of that. And so at the end of the day, you're probably looking at something around $2,500. You would also have to pay a one-time appearance fee, and it's roughly about $189, and that goes to the clerk of the court for McHenry County. These aren't fees or charges for my firm. These are fees and charges from outside third parties. And that is something that property owners should be aware of, because it is important for them to understand that going in. But absolutely, these costs are without question investment in a greater return. I can't recall a client that has had a case where we've expended these dollars and they haven't wound up in a financially superior situation. You're not looking at getting an increase of a couple $1,000s where it's a wash on the expenses. At the end of the day, in order to go through this process, there's got to be a substantial financial gain in the process that merits bringing these people involved. And so those are expenses, I think, that the property owner should be aware of, but absolutely they are an investment in greater return, and no expenses are incurred, not at one, until the client authorizes it. And there's a conversation about why we're incurring the expense, what that expense will be. And then there's approval from the client saying, yes, we want to bring that person on board. And I'll make a recommendation. I'll say that I think we should bring this person on board and this is their fee, or we can go this other route. But I would tell you now, the property owner should anticipate that you have to get an appraisal. Otherwise, all you're doing is going to IDOT or going to the judge and saying, I'm entitled to more money because my property is worth more money, or I don't think they're paying me enough. You need to provide a basis to the court as to why you're asking for more compensation. So that's the general process. Again, I'm giving you kind of the tops of the waves, or encapsulating things in kind of a briefer nutshell. So that's the kind of legal process. Shifting over to the current status of this project, as I understand it from talking to different people at IDOT and understanding where things are at. They're going out now to various property owners, and they've sent letters and they've done site visits at many properties along the way. So they're doing that now currently. Again, you have no obligation to let them into your property. You have no obligation to meet them. You have no obligation to answer their questions. You're not obligated to do any of those things. Again, as I said before, you should try to treat everybody, with respect, and you don't have to treat them. You don't have to be happy that they're coming out to appraise your property, knowing that it's for them to acquire a piece of your property. But at the same time, these individuals are doing their job, but you are not obligated to talk to them. You're not obligated to let them into your property. In fact, you're not even obligated to let them on your property. I do think, though, that you can let them on your property without any concern. So that's taking place now. They're hoping that by Thanksgiving of this year, 2021, they'll have completed all the appraisal reports, and that and they have to put these things all together, and they have a review of those appraisal reports done, and then they get them to what, as I mentioned, for the negotiator. So they'll get them to the negotiator, and that the offers are hoped to be made to all the property owners in January of 2022. And that after January 2022, you'll go through a process in which they allow you to kind of look at the appraisal reports and understand them, and potentially have questions answered if you have questions. And then that's when the negotiator will contact you. Again, I don't believe that negotiating with IDOT is a constructive process. I think it's one in which many times vulnerable aspects of property can be unknowingly disclosed. I think you have to be aware of everything you say to IDOT, especially it's a negotiator, is because they maintain what they call a negotiation log, where they record every phone call that they make to you, every phone call you make to them. And so anything you say to them and anything you give to them will be captured in that negotiator's log. And then when the case does not resolve itself, which unfortunately I'm going to guess that many property owners will not find it easy to negotiate with IDOT, that law gets turned over to the attorneys that represent IDOT, and that puts the property owner at a bit of a disadvantage. So that's why I suggest the property owners are very cognizant and try to minimize what they share with the property owner, with the negotiator. So the offers are supposed to come out in January of next year, January 2022. And then they're planning to start the condemnation, the legal process to acquire property in the summer of 2022. And that they're looking to start construction, and it's probably going to be utility relocation. They have to move, electrical, they have to move the street lights, underground infrastructure such as telephone lines and drainage lines and things. They do a lot of that, and they're hoping to do that in the summer, starting in the summer, probably late summer next year of 2023. And then they'll be doing active road construction where they're ripping up the road and taking down, removing curbs and excavating and removing asphalt and laying new sewer lines and such in 2024. And the expectation is that this project is going to be 2, maybe 3 construction cycles. And what is that? Or construction seasons. And what's a construction season? In Illinois, asphalt plants kind of dictate when construction happens. And so asphalt plants open typically at the end of April and they close in the beginning of November. And why is that? It's just because the temperature is too cold. You can't place asphalt down when the temperature is too close, and the asphalt plants in Chicago metropolitan area closed during that period of time. And so this project is one in which they're expecting 2 to 3 construction seasons. They don't know because things don't always go according to schedule, especially when you're dealing with the state of Illinois. Unfortunately, things don't always happen on time. They may have a projected timeline, but things don't always happen consistent with that timeline. So that's the rough timeline. As Jim said before, he had gotten contacted or came back and an appraiser had stopped his property. What do you do in that situation? Or what if you do if the appraiser isn't there, but you left the card to call? As I mentioned before, you're not obligated to contact them. You're not obligated to let them on your property. You're not obligated to let them into your property. And you're certainly not obligated to share any documentation at all with them. And I would encourage you, if you have questions, to call and contact us, and we will help you look at the situation and the requests that are being made by the appraiser. But I don't think it's in the property owner's best interest to do that, to provide documentation. But if they do come out, it's a situation, I think, where they should be answering your questions. They're coming out to take your property. They should be advising you what's happening, how much land is being taken, how far away from the frontage of your building is it being taken. And all of those measurements should be called out in what I mentioned or referred to before as the plat of highway. So they should be able to answer all of your questions about this. This should not be a scenario in which they are asking you questions and you are providing them information. I would not disclose to them if you recently refinanced or you have a new mortgage on your property, because maybe that suggests then you have an appraisal. If you do have an appraisal, I absolutely would not give them that appraisal. That appraisal will, if anything, would only have one value that's relevant to condemnation, and that's the value of the property before. That's the first value. You need the value of the part taken, which is what you're getting paid, and the value of the property in after the take, which reflects the damages. Those conclusions will not be in any appraisal report that's in your possession at this point in time, because it's an eminent domain appraisal. So any appraisal that you have would be related to a lending institution or perhaps maybe an estate evaluation. I would not suggest that you provide that, because those are done under different circumstances. And I also think that they could artificially impose a ceiling on what you're able to secure in compensation. And I also would strongly recommend that you do not go out. If they suggest, oh, you should go out and do this, they want you to go out and do it. You should not go out and secure an appraisal of your property. They will probably tell you, if you try to negotiate with them, that you need to get that done. Do not do that, because chances are you'd be getting an appraisal done by somebody that may not be quite as familiar with eminent domain, somebody that may not be quite as, and I've talked to certain people because I've had clients say, oh, I want you to hire this person. And I've talked to that person and the person doesn't understand it, or they're hesitant to come up with an opposing opinion of value that's different from what IDOT says, and they're reluctant to push back on IDOT. Those are not the individuals that you want to kind of the team of horses that you want to hitch your carriage to. You want to make sure that you're prepared and that you have knowledgeable and experienced individuals. And there are individuals that we work with that do that, but do not go out and get an appraisal done on your property, because that will not help you. And, you know, so you go through that process. If those things are suggested to you, you should not be doing that, because that will not help you in the end goal, which is to protect your investment. That's the main goal here, is to protect your investment, protect the value of your property, and ensure that you're getting the compensation that you deserve. And, you know, I don't think you also need to be an advocate for your property. I think the value that the appraiser is going to come to and conclude with is going to be the value independent if you said anything or not. So if you say, go through, oh, we just did this work. Did you do it pursuant to permits? Did you get obtained plans? If you did, perhaps maybe that'd be something you disclose. But if you didn't, or you're not quite sure if the plans or permits were as comprehensive as the work you did, then I think you need to think twice, because that could wind up being something that they use against you to devalue your property or to exclude those improvements. An appraiser can recognize if all new windows have been put in a storefront. The appraiser can recognize just simply by seeing if the if the interior of a building has been remodeled, can see if the asphalt has all been replaced and the parking lot restriped. Those things are visually apparent to an appraiser. These appraisers have been doing this work for decades. They do not miss those things, whether you tell them or not. They're going to recognize those things if they exist, and whether or not you tell them, they won't say, oh, those must be old windows because the property owner didn't tell me that. I don't think you need to be, again, an advocate for your property, because you need to make sure that you have a clear understanding about what you're disclosing and why you're disclosing it. And there's a strategy in mind to doing that. So there's a lot of different things to take into consideration in this process, and I could go on, but I'm sure that there's different people that have questions about this, about the condemnation process and the various topics that I talked about. And IDOT, and I think one question that's come up that we've seen in the Q&A is, what are the damages? IDOT does not restore your property. They won't come in and replace your sign. They won't come in and replace your shoebox lighting for your parking lot. They won't come in and restripe your parking lot. What they will do is they will pay you compensation, and that's a term called cost to cure. That's rolled into the damage to the remainder category that I talked about before. And so don't expect IDOT, oh, you're going to replace my sign, you're going to get me a new sign and you're going to install it. No, they will pay you compensation, and you have to undertake that work to get a new sign and to get it reinstalled. I mean, there are issues with these temporary easements. My guess is they're going to take a strip of land along all the frontage of all the properties on the east and west side of Route 47, but beyond those takes, they're going to do a temporary easement. So there's issues that come up. All right, so I've got my sign in the take. Now I can't relocate. I can't take my sign out of the take and put it on my new frontage. Why? Because my new frontage is now going to be impressed by a temporary easement. What does that mean? In my opinion, that means that IDOT needs to pay for temporary signage for the interim while they've got that easement impressed. And so now when that easement is released from your property, you're entitled to get a new sign and installed. Maybe the old sign isn't going to withstand the reinstallation and multiple moves, and maybe it's an older sign to begin with, and it no longer complies with Woodstock zoning code. If it doesn't, then we'll look at those things, and we have individuals that we work with that will opine and provide an opinion of value and cost to do that work. So there's various issues, and there's other things such as variances that might be needed. If you can no longer put your sign back, what do? Well, you need your sign, and Woodstock's going to allow it. And many times they'll say, oh, well, look, this isn't your fault. It was a forced acquisition. That's what IDOT will say. It wasn't your fault. Well, that's fine. But when you go to sell your property 5 years down the road, 10 years down the road, and you have to disclose to the purchaser that your sign doesn't comply with the zoning setback, or that's captured in an ALTA survey because somebody now realized your sign doesn't comply, if you don't get compensation for that issue now, You can't go back to IDOT later on and say, oh, I'm looking to sell my property and I need to get compensation because my sign doesn't comply. Now is the time. You need to make sure that all of these issues are addressed now. And that's why I said before, you want to make sure you're preparing for that. So those issues definitely come into play. If your property isn't, many times if you fall out of zoning compliance, and that's an important, zoning is an important issue. You fall out of zoning compliance, meaning your building doesn't sits too close to the right of way now. Your sign sits too close to the right of way, your parking, what have you. Some of those things you can't cure, some of them you can. The municipalities frequently have a provision that allows for them to enforce the entirety of your zoning code if you're going in to get a permit. They say, well, look, if you're getting a permit to do these improvements, I want you to correct everything on your property that doesn't comply. So if you're looking at improvements in the part taken or the temporary easement that are going to be damaged, know that IDOT isn't going to be fixing them. Will they regrade your property? Yes. Will they throw down some grass seed? Yes. Will they put down asphalt or a curb? Yes. They'll do those basic things, but anything beyond that, they will not do. They will pay you money to do it. And we need to make sure that the issues and the scope of work is, one, properly identified in terms of what has to be done, and two, that it's properly valued. And we have people we work with to do that. And then we get the compensation. So often that's an issue of negotiation. And I would tell you again also that you don't want IDOT paying its contractors to do the work for you. You want to be in charge. You know best your property. You know best how it should be restored and how to preserve the value of it. And if you turn that over to IDOT, I just think that that's a recipe where for potential disaster, where the contractor is not beholden to you because you're not paying them. The contractor is beholden to IDOT, and they're just going to be doing the work consistent with what IDOT says. To the point that questions come up about mature landscaping, the loss of mature landscaping. If you're losing landscaping, it's not an issue that IDOT will oftentimes value it and say the part taken is X dollars, and then they'll provide an enhancement over and above the basic dollar amount for the land that's being taken. So then maybe they'll say it's $5. I'm just using round numbers by way of example, $5 per square foot. And they say, well, the area that's being taken is a bunch of mature oak trees. And so we're going to increase the value of that part that's being taken by $1. So now they're going to offer you $6, and then they multiply that out times the square footage that they're taking. In my opinion, the value of landscaping is not the value, what it costs to replace it in and of itself. It's its contributory value to enhancing the value of the whole property. So you have landscaping, you have site improvements, whether it be an irrigation system, lighting, etc. Those improvements increase the value of the whole property. And when they are gone, it's just not the cost associated with replacing them. It's that cost plus the contributory value of those improvements. But unfortunately, if you go in and you get an arborist to come in and say, look, I've got these oak trees that are 80 years old and you're taking out 3 of them, and you come to a value, and they do have value from an arborist standpoint, IDOT will not pay that contributory value, because you look at a piece of property and let's say you've got a single family house and those trees add up to $50,000 a piece. IDOT's not going to say, oh, I have to pay you $150,000 for those trees, because again, the market is going to be looking, and this is how we're looking at the market is not, if you have 2 homes that are very identical and you have a buyer that wants to buy both, buyer might say, look, I'd love to buy the house with the mature oak trees, but I'm not willing to pay $150,000 more because it has those 3 oak trees. I will pay more than the house that doesn't have any oak trees, but I'm not going to pay that much more. And that's the compensation that you're entitled to. And that's what the appraiser helps identify. What is the difference? And again, that analysis is a bit subjective. It's based upon your experience in doing these types of cases in all around the Chicago metropolitan area, whether it be a condemnation case in Kane, a condemnation case in Will, Cook, Lake, DuPage, or McHenry County. So I hopefully have taken the time to answer any questions that people have. I think that some of the questions that have come in that we've gotten fed to us during this discussion, we've already addressed in the presentation. To the extent that there are questions that we haven't answered and that you have, or that you think about after this, please don't hesitate to contact me. You can email, and I believe that that's something that we have up on the information for this webinar, but my email address is my first three initials, B as in Brian, P as in Patrick, L as in Lynch, at blynchlaw.com. Olivia just threw it up in the chat. And of course, you're welcome to telephone my office, and Olivia will also put that up in the chat for everybody, but just I'll give that to you now. That's 312-573-2727. And I welcome your calls and questions. There's no obligation to, and there's no fee. There's no obligation to retain my firm. There's no obligation to pay anything. Feel free to contact us. We're just trying to provide a source of information to the affected property owners in this project so that they're aware of what's going on and that they've got somewhere they can get their questions answered to, because unfortunately, up to this point in time, everyone is getting all the information from IDOT, and they're trying to make their decisions, and will be looking at making their decisions based upon that information. And I just think it's healthy and appropriate that they have a second source of information to help give them more of a rounded perspective on the issues that they're facing. So thanks again for everyone's time and participation and attending tonight. And
Brian, I got one quick question for you.
Sure.
So as a property owner, between the time the appraiser comes out and does his work, and as a property owner, there's certain things that happen, whether it's your land or you're building things, and you have these improvements that you need to make or these additions you need to do. What happens after the fact as a property owner, after the appraiser's already done his job and you need to do these things? What should you do?
I would say that, and it's a great question, Jim, and it's something that I'm glad you brought up. If a property owner, by way of example, let's say you have a property, your commercial property, and you're in the middle of a renovation, you want to complete, you have to complete that project before. So if you're contemplating any improvements or you're in the process of undertaking any improvements, you need to complete those improvements as soon as possible. You absolutely need to complete them before they would go through the court process, because once you go into the court process, and you won't be able to delay that, when they're going to go to the court, they're going to go to court. And so when you go to court, your property is kind of like frozen in its condition. So if you're in the middle of a rehab of your office space and it's not complete, if they file that date, your property will be valued in the marketplace as a piece of property that's under renovation, and it won't be given the value that it would have upon completion of those renovation improvements. So it's important. So when they come out now and value it, if your property isn't complete, so be it. They will note that. And that's the other thing why I don't always suggest that they come into your property. That's not going to be a positive for you if your property isn't completed. You tell them, oh, I'm planning on doing this, or I'm planning on doing that. Why are you fixing your roof? Is there a leak there? I mean, it raises other questions that I don't know that you necessarily need to delve into. I just think that they can see things. And if your property, if you're contemplating 2 months, in a month, to maybe redo your roof or redo your parking lot or do some improvements, do those improvements. They don't have to be made aware of them. When they file their court case, they have to, because everything is frozen as of the date that they file that lawsuit in time from a valuation perspective, they have to go out and do a new appraisal report. And that's why if things aren't done now, it's not the end of the world. And it's not like, oh, I got to finish this. There's no way I can finish it because they want to come out in a week. I wouldn't worry about that. And we can talk about the particulars if you've got questions in those situations apply to you, but I wouldn't worry about it. I would just let them do the appraisal report, but perhaps maybe not let them into your property, not let them be able to observe what you're undertaking, what work you're undertaking, because again, I don't think that that's necessarily going to be beneficial to you. Certainly not in their current offer to you, nor would it be beneficial to you later in the process, because you may just have issues that can't be addressed in between now and the time that they file the lawsuit.
Great. Brian, appreciate you coming out today, and answering everybody's questions and following up with all of us. On behalf of ourselves and Brian, thank you, everyone. We're going to send out an email. There was a lot of information here. We think that it was very helpful. We think that, if you need to go back and listen to it again, you can certainly do that. But again, if any questions, reach out to Brian. He put his email up there, and we'll certainly send it out to you as well if you need it. But again, thank you for your time, and everyone have a great night. Appreciate it. Bye-bye now.